Let's bring in our guest, still with us, criminal defense attorney, former prosecutor David Bruno. David, your reaction?
Yeah, the good news for this defendant is that at 30 years, she'll be eligible for parole. The bad news for this defendant is that the parole system heavily factors in the victim impact statements. And I believe that this family and these victims will be at every single parole hearing all the way up until the maximum, which could possibly be 60. So the range is here for the parole board now. And the judge followed the recommendations. And we see it in the state system. Oftentimes it's probation that makes recommendations. The federal system, there's also the similar sentencing guidelines that gives judges ranges and guidelines. And in this particular state, the judge went with that 30 to 60. And again, 30 years without parole that this defendant's going to have to do.
Yeah, she'll have to serve that 30 years before coming up, and I agree with you. I don't think she's anywhere near parole in those early years. She's probably going to have to do a little bit more than 30, significantly more than 30 possibly. There's something else I wanted to ask you. You're a defense attorney now, former prosecutor. One of the things that I noticed about this plea, it was a no contest plea. 8 counts of operating while intoxicated, causing serious injury, but only 1 count of the homicide. I found that interesting because 2 people died here, but they dropped 1 of the second-degree murder charges in this instance. Why would prosecutors do that under the circumstances?
There's only really one explanation, Michael, and that's for the plea. That's for the plea. Because if this were to go to trial, certainly they have 2 bodies, 2 separate counts. And, then there would be the consecutive versus concurrent arguments, and every life really is worth their own sentence. And that's a good argument for the prosecutors in that sort of situation. So I think, look, they had to give her something, and she did accept responsibility. And I think that's something good for her that at least went into her factor on this, because if this went to trial, Michael, she would have been guilty on the 2 homicides, all the other victims as well. And in a blanket sort of sentencing with a guilty on all, it could have been life sentence, and she could have never seen it. Definitely.
Yeah. Yeah, I would have to agree. I think maybe this one might have worked out for both sides, but maybe not so much for the family, David, because that nolo contendere, the nolo contendere plea, that no contest plea, a couple of them mentioned, David, that they didn't feel closure. Matter of fact, they called her a coward for taking that plea. They said it caused more pain, the way she was dealing with this. And again, you talked about she took responsibility. I don't think they felt she took responsibility with that particular plea.
Yeah, when I say she took responsibility, I mean, she could have went to trial. And then she at least, took a plea deal, and yeah, it was nolo contendere. And oftentimes that's for the civil reasons, right? However, don't get it confused, audience. I mean, the civil case could be proven by any shadow of a doubt. It's a lower standard, preponderance of the evidence. We talk about this frequently in our criminal system when we have civil cases as well. So really, it doesn't really get her that far in the civil case. And I just wonder if that was the right decision. Maybe she would have gotten a little more leniency if she gave a factual basis and admitted guilt.
Yeah, I would agree. And that guilty plea would have allowed her to say something as well to show that remorse herself. All right, David Bruno, thank you so much for joining me tonight. Always a pleasure to have you, my friend. We'll see you again real soon. Folks, stick around.